Hey everyone, I'm Kelly Longtin from Kelly Longtin Law, and today I want to talk to you about including non-citizens in your estate planning. With our society becoming increasingly mobile and international travel becoming more affordable than ever before, families and family-like relationships have steadily grown far more diverse in terms of citizenship. It is no longer uncommon for spouses from different countries to retain citizenship in their native countries. Many couples split their time between the United States and another country to be near their families and enjoy the many benefits of such a lifestyle. In addition, it's not uncommon for a couple's children or other loved ones to move away from their country of origin and take up permanent residence abroad, or even renounce their home country citizenship, depending on their choices of careers or domestic partners or other considerations. Diversity of citizenship among friends and families also creates a fair share of complications. One complication is in the area of estate planning, which may be one of the more overlooked challenges of citizenship diversity within a family. Estate planning law is already complex. Adding international legal issues to the mix can exponentially increase that complexity. Therefore, you must seek competent legal advice for your specific situation. Articles such as this can serve at most only to raise awareness of some of the complexities. And discussions like this raise awareness of the complexities that you're likely to encounter when engaging in such planning. An important threshold question in estate planning is whom you should name as your legal representatives to handle your personal affairs if you become incapacitated or die. If you're a U.S. citizen and you own accounts and property in the United States, there may be unforeseen consequences if you name a non-citizen spouse or friend or a family member as your executor or your trustee or your agent under the power of attorney. In many states, there are few restrictions on whom you can appoint as your executor or personal representative under your will. And if you have a non-citizen child or a spouse and you trust that person above anyone else to handle your affairs after your death, then you can name that person. As long as he or she follows the laws of the state where your will is probated, your designated person can carry out the executor or personal representative duties without a problem. Some states, such as Florida, still require that the executor of your estate be a U.S. citizen. It's important that you know about all these state-specific differences before executing your estate planning documents. Even if a particular state allows individuals to name a non-citizen executor or personal representative under a will, it does not necessarily mean that that is a good idea. There are important practical considerations too, such as day-to-day management of real property owned by the estate or the collection and safeguarding and sale of personal belongings and pets and businesses. Asking someone who lives in a foreign country to handle such affairs could impose a heavy burden on that person and create significantly higher administration costs. In addition, having a foreign executor may make it much more difficult for your beneficiaries to legally compel the executor to fulfill the position's duties if that person fails to properly carry them out. Today, many people use a living trust for estate planning purposes. This legal tool has many benefits, including the ability to avoid probate and ease of administration for the trustees. But take care when naming a non-citizen as the successor trustee. If the trustee is a non-citizen or a U.S. citizen who resides outside the United States, the trust could be treated by the IRS as a foreign trust, leading to adverse tax consequences for the trust's beneficiaries. For example, if the trust is deemed to be a foreign trust, the IRS could impose mandatory withholding requirements on the trustee or recognize capital gains tax on appreciated assets such as stock even before the property's sale. Now, certain tests must be applied to a trust to determine whether it qualifies as a foreign trust. These tests are fairly technical, and a drafter of the estate plan documents must take great care when creating a trust that will have a non-citizen trustee or successor trustee. Naming a non-citizen as a trustee may raise challenges similar to the ones described above for an executor or a personal representative. Because of the potential risks and complications associated with naming a non-citizen as a trustee, consider naming a U.S. citizen who resides in the United States as a co-trustee to serve alongside the non-citizen trustee. Naming a trustee who resides outside of the United States may also subject the trust assets to the laws of a foreign country and expose the trust to potential taxation by that country. If there is no one whom you trust to carry out this important responsibility, you may need to hire a professional trustee, such as a U.S. corporation, bank, or an accounting firm that routinely performs this function. Doing so can protect your named beneficiaries from unintended negative tax and legal consequences. Of course, there may be higher administration costs with a professional trustee, but the value that the corporate trustee's professionalism and efficiency will generate often far outweigh the higher cost, resulting in potentially greater savings to the trust and its beneficiaries than you would gain by choosing a family member or a friend to be the trustee. There is also some question as to whether a U.S. citizen can name a non-citizen as an agent under a financial or healthcare power of attorney. In most cases, you can name any person whom you trust to be your agent under a durable financial power of attorney, a healthcare power of attorney, or advanced healthcare directive. However, some states may have specific requirements for a non-citizen serving as an agent. It is most important that you choose someone you trust to make decisions for you if you are incapacitated. Naming a non-citizen that you trust may be worth any hassles the person may face. Nevertheless, you may still want to consider the practical challenges that can arise if your chosen agent is living outside the United States when the agent needs to act on your behalf. Will the distance and the travel requirements impair the agent's ability to act quickly? For that reason, it may be a better idea to name a resident U.S. citizen whom you trust to act as your agent to avoid any question about the person's authority to act and the ability to act quickly because of their proximity to you, proximity to your healthcare providers, and your United States-based accounts and property. A related but different problem arises when a beneficiary of a U.S.-based trust or estate is a non-citizen or a U.S. citizen who lives in another country. An executor or the trustee that pays income from a trust or estate to a foreign person as defined by the tax code is typically required to withhold 30% of the funds prior to making such distributions, regardless of what the ultimate tax liability will be. These mandatory withholdings can create additional complexity and administrative costs and result in smaller distributions for the beneficiary than what the creator of the trust may have intended. In addition to the withholding requirement, naming a beneficiary who resides in a foreign country may allow the foreign country to tax the property and the accounts of the trust. Another important issue to consider is that, in contrast to spouses who are both citizens of the United States, if you have a non-citizen spouse, the unlimited marital deduction for gifts and inheritances passed between spouses is not available to you. Certain complex rules apply when determining what you can leave to your non-citizen spouse free of estate taxes. In addition, the non-citizen spouse is not subject to the presumption that each spouse owns 50% of jointly owned property. Instead, a non-citizen spouse must be able to trace the amount of the spouse's own money or earnings contributed to the purchase of the joint property. Failure to do so could result in significant additional tax liability at the death of the citizen's spouse. Note that some international tax treaties between the United States and other countries may impact the withholding requirements imposed by these IRS rules. Thus, it's important to obtain competent legal advice if you intend to name a foreign beneficiary in your estate documents. All this being said, do not let the fact that you have a loved one who lives abroad or who may have maintained citizenship in other nations discourage you from planning your estate. Just realize that you may need additional help to understand how state, federal, and international law will apply to the decisions that you make. It will be well worth the effort, and we are delighted to help you along the way. Just give us a call. So I'm Kelly Longtin from Kelly Longtin Law, and today we're talking about when you have a foreign person as a beneficiary of your trust, or as a trustee or an executor or personal representative. If you have any additional questions, please contact us at info@kellylongtinlaw.com. Make sure that you follow us on YouTube and any other social media channels that we're on. Thank you for joining me today.